May it please the Court, I'm Joshua Gordon. I represent Dana Duxbury-Fox, who's here, and who, since she's been a small girl, has been enjoying her camp in Tuftonboro on Lower Beach Pond. The Shakhnoviches looked at their deed and they saw a single phrase written by the neighborhood insurance agent, and they've spun a whole theory out of it. But in spinning this theory, Shakhnovich ignores a dozen really big facts. First, he ignores the inconvenient language of his own deeds, which names the shore owners, not licensees, who now and formally have been permitted to use the right-of-way. Now and formally indicates rights that extend historically beyond current ownership.
So you say that parcel was burdened by a right to pass and repass?
Absolutely, and that now and formally indicates it runs
now
with the land.
Now and formally is where, in the 1930 deed?
Oh no, this is Shakhnovich's own deed.
Oh, okay.
What they claim is the permission clause. It's not quite so simple. It doesn't really just grant permission in a license. It grants something much greater than that. The careful reading shows. And so even that deed that he bases his argument on is not quite so permissive. Second, perhaps he's conceded it, maybe not, but it's in his brief, Shakhnovich ignores Duxbury's shorefront deed of 1930. It provides her a right to pass and repass by her heirs and assigns. Now that's that language no longer necessary, but it indicates a right-of-way and not something less permanent. And in his brief, he cites Admonson and Walsh deeds, but those deeds are not the same as my clients. They're much more restrictive. They're subject to gates and bars. Some of them don't have rights. They're differently worded. My clients, the 1930 deed is most definitely an easement. Third, he ignores Duxbury's 1976 deed to the backland. It makes quite clear that it is the footpath alternative, and it's a footpath, not a woods road. It's a footpath, and that one, her back lot has a footpath easement, and her front pond lot has the 1930 easement.
It sounds like that there was this easement and it was relocated. Is that fair to say?
Well, after 1930, Duxbury had an easement to the sandy beach.
Okay, but then when they did the subdivision in 71, it was relocated.
It was relocated.
Okay, so what's the legal authority they have to relocate the easement?
As long as no one objects, relocation is permissible. It's spelled out in my brief. There's no legal impediment if there's no objection by anybody. And that's what was done. The subdivision created a right-of-way, and it's labeled right-of-way, and that's where the right-of-way was moved, about 200 feet to the west.
So why is that an easement and not a license?
Well, several reasons. One, it names the shorefront owners, and it calls them owners. It names them as now or formally. It indicates a right-of-way. But I think you have to look at it in tandem with Duxbury's own deed, which most clearly gives her an easement. And that's the standard way of doing it. It's the dominant estate that owns the easement that has the easement language, and that's exactly what happened here.
But doesn't the easement in her deed relate to the original one that was, before it was relocated?
Yes. It refers to the sandy beach by custom. That's what everyone was doing when it was moved in 1971. Right. It was moved 200 feet to the west, and that became the right of way.
Right, but I think his argument is that you still have that easement over here that was created by the deed, but now you have two. You have an easement and you have another easement. If I understood his argument correctly.
If I understood his argument, I think he's talking about actually 3 easements, but I think we can take the easement, that's the footpath, that is way over here, way over on this side. The footpath, that's accounted for in the 1976 Duxbury deed. Okay. After 1930, Duxbury used the sandy beach, which is on page 12 of my brief, used the sandy beach over in here, and this is where they docked their boats.
Is there any official relinquishment of the sandy beach easement, and if not, should there be or should there not be? In other words, I think, following on with Justice Duggan, maybe there's still the sandy beach easement and as well the one that's along the opposing party's property, but shouldn't there be only one instead of both?
Well, when Brown owned everything along along the road from the culvert to the west. And he sold right near the lot 14, right near the bridge. He sold this to Ringer. He sold this lot 14 to Ringer, and he had already sold the Snow lot to Snow previously. And so when he created the subdivision, he created this map, and that's Brown's handwriting. It says right of way Brown between them, intending to move the easement.
Is this recorded?
The recorded version is in the very back of my brief. On page 34 is the recorded, unadulterated version. I amended this slightly to put some labels in it as part of my fact statement.
So getting back to my question, does the Sandy Beach easement still exist?
I don't think so. I think when Brown sold it to Ringer, and created that subdivision, he moved it. He moved it 200 feet to the west. And so Ringer didn't want to buy a beachfront house with a bunch of people using essentially his front yard. This right-of-way is separated from Shakhnovich's land. It's when you look at it, which the judge did, it's 50 feet wide. It very much looks like an easement. It's paved with gravel. It looks like a parking lot. It's obvious that it's a easement from the road to the pond. It's separated from Shakhnovich's land by about a 4-foot drop with a stone wall and some greenery along that drop. It's not in Shakhnovich's, it's not in his face, whereas the Sandy Beach really is right in front of Ringer's front yard. And the other problem was these people, the campers, were parking on the road right at the bridge, at the culvert. And I don't think no one really liked that solution. So when he created the subdivision and the easement, he created it 50 feet wide so that it could be used as a parking area. And that, after 1971, that's how it was used until 2005, for 30 some odd years. The campers parked their cars, had a little dock, I don't know, it's about 15 feet long or something, docked their boats, parked their cars, docked their boats, went back and forth in the camps. And there really wasn't a problem until Shakhnovich saw this word permission in his deed. But in seeing that permission, he just ignores so much. He ignores not only my client's deeds and the documents, but he ignores what he can see out his window. He ignores, like I said, the strip looks like a right-of-way. He ignores that Duxbury and the other campers don't really have any other practical access to the road. Brown Road veers up the hill, off to the other direction. There is no practical access to the camps. He ignores that the land between the road and Ms. Duxbury-Fox's land is a craggy hill and not practical to build a road. And he ignores that the footpath, which is unmarked, it's a half-mile long, it's legally only 3 feet wide, as a practical matter, not capable of really supplying a house.
But we don't have an easement by necessity issue before us, do we?
No, I think if these deeds didn't exist, they'd probably have that argument. I think the biggest thing Shakhnovich ignores is what he sees out his window is the campers themselves. He knows they live across the pond. They're named in his deed, or their predecessors are named in their deed, and he sees them every day, parking their car and loading their boat and transporting their supplies. And he ignores that the campers have been doing this exact same thing for 75 years. The court below didn't ignore those things and properly granted the petition quiet title, declaring that my client has a deeded right-of-way.
Thanks very much. Case submitted. Thank you.